Everyone, welcome back to my channel Sans Global Immigration. This is Neha Bhalla, regulated Canadian immigration consultant. And on our channel Sans Global, we talk about Canadian immigration, everything related to Canadian immigration, maybe study permit, maybe work permit, how to work in Canada, how to study in Canada, how to become a permanent resident. So everything related to Canadian immigration. And if you are watching this video, then it means definitely, if not definitely, most probably you must have applied for any application maybe related to study, work, or your permanent residency, or any other application like visit visa for your Canadian immigration or Canadian visit purpose. So if you have applied any of these applications and you are experiencing more than usual delays, normal delays is fine. If you are facing more than usual delays on any of your application, then this video is for you. You must watch it to know what is the last resort to do, what is the last option that you can do in case you are not getting a decision on your application. So when you don't get result on your application from a long duration, what you generally do? So whenever some people reach to me for consultation and everything, so the basic steps that they have already taken, or the basic steps we tell them to take, these are the three basic steps. So first is calling IRCC. So you generally call IRCC, you inquire about your application, like what is the status of the application, right? So this is the first step usually everyone take. The second step is raising a web form. So you can also raise a web form to IRCC to inquire about the status of the application, like what is going on your application, why is it taking so long. You can inquire about it through a web form. And the third option is the ATIP request, which is requesting the GCMS notes. So most of you must be aware what GCMS notes are. GCMS notes, are a detailed note about your application, like any notes on your application which the visa officer has noted. So basically you request these notes just to know where the application is right now, what is the status, which part is done, and what steps are left in your application. So you request the GCMS notes. So these are the three basic steps which most of the people take when they're not getting a decision on their application. That is either calling them, web form, or a GCMS notes. So now you have tried all these three options which we discussed, but still you haven't received any results from IRCC, or maybe no response even from IRCC in answer to the three options which you have tried. So now in today's video, I'm going to tell you one option which I would say is the last option that you should undertake to get a decision on your application. And I would say that this last option which I'm going to tell you is such a strong option that only a few of the people have taken this route, this option they have taken. And they not only got the decision from IRCC, but IRCC also paid them funds, like in some cases $1,000, in some cases $2,500, depending upon the situation of the applicant, to cover up the cost basically, for keeping them waiting for so long. Now I'll explain this last option to you with the help of an example, of a family who actually opted for this option. So there was a family who applied for permanent residency in 2016. So they got the PNP invite, they got nominated, and they finally put their PR application. And they did not get any response on their application for like around 4 to 5 years. So that was a long time. So what last option they did was they asked the court. Yes, they asked the court to issue what's known as a writ of mandamus. Mandamus is very important over here. So they asked the court to issue this mandamus, basically to compel to ask IRCC to process their application. So the court will ask now the IRCC to process their application. So the court in this situation, they looked at the complete situation and they ruled, they gave the decision that, the family met the requirements of an order of mandamus, as the delay in their situation was actually unacceptable. Like think 4 to 5 years waiting for your PR decision is actually unacceptable. So, and IRCC then was unable to provide any answer to the court that why there was a delay on their part. They could not explain this to the court. The court, it gave orders to the IRCC. It asked IRCC to, complete the processing of PR for this family within 90 days. And not only this, not only they gave a deadline, but they also asked IRCC to compensate the family with $1,000. For why? Because they were waiting for so long. So IRCC had to compensate this by paying $1,000. So this amount is decided by the court that IRCC has to pay. In another case, IRCC ordered IRCC to pay $2,500 to a family for keeping them waiting so long on their application. So it depends upon IRCC, upon the court, that how much amount IRCC had to pay as a compensation to the applicants. But it is not always that the court will agree to issue a mandamus. In one of the another situation, let me talk about another situation in which the court denied to issue a mandamus. So an applicant went to the court and requested the court to issue a mandamus so that IRCC can process its application faster, but court denied the request of that applicant. So in this situation, the applicant had a bachelor's degree and also he had a master's degree, and then he applied for a study permit to study inside Canada for a PhD program. His application was delayed and he did not get results for like approximately 2 years. So he asked the court. The court said that, as a result of the delay in the application of his study permit, the applicant, already had a bachelor's and a master's. The court said that, the delay in the application, delay in the processing time by IRCC, that there is no sufficient loss to the applicant, that he does not face any loss, because he could have studied anywhere else. So this was the statement given by the court, and due to this, the court did not agree to issue a mandamus. So as I said, this mandamus, this writ of mandamus is an extraordinary measure. It's not an ordinary route, ordinary remedy to be used when you're not getting decisions on your application. So it's an extraordinary measure to be used only as a last resort. Yes, writ of mandamus is an extraordinary remedy, not a normal ordinary option for you to opt for if you're not getting the decision on your application. So if you are facing serious delays in your application, a writ of mandamus can be an option. Yes, it's an option, but I would say it's usually a last resort, a last option. So there are other steps you should take before opting for a mandamus. Because if you opt for a mandamus, you go to the court asking to issue a mandamus order. They would also ask you, they can also ask like, what steps did you take first to get a decision on your application or to inquire about the status of your application. So you should already have done those steps. So those steps are, as I talked about, first is you have to call the IRCC, calling an IRCC, raising a web form, ordering your GCMS notes, or in the last situation, what you can do is you can hire an RCIC, that is an licensed consultant or an immigration lawyer you can hire basically. Why? Because they will raise a web form for you. They can write a professional letter inquiring about the status of your application, and also they can mention about this consequences you are facing, any problems you are facing because of the decision not being given on your application. So I hope the video was helpful to you and you understood that yes, there is another option, that is the mandamus. But yes, do remember, it's a last resort option. Exercise only if required, because it's up to the discretion of the court to accept to issue a mandamus or not. And yes, if you like my video, do like it, do share it with your friends and relatives, and don't forget to subscribe my channel, as we do talk a lot about Canadian immigration. Thank you so much.